Judgment in the matter of Merticariu against the Judecatoria Arad, Romania.
Again, Lord Stevens will explain the court's judgment.
This appeal raises an important question concerning the proper interpretation of Section 20, subsection 5 of the Extradition Act 2003. Section 20, subsection 5 imposes a duty on a judge at an extradition hearing to decide whether a requested person convicted in their absence would be entitled after extradition to a retrial in the requesting state. The appellant submits that on the correct interpretation of Section 20, subsection 5, there must be an entitlement to a retrial in the requesting state, which is not dependent on any contingency except for purely procedural matters, such as making an application in the manner and in the time prescribed in the requesting state. By contrast, the requesting judicial authority submits that on the correct interpretation of Section 20, subsection 5, it is sufficient for there to be a right to apply for a retrial to a court in the requesting state, even if the success of that application is contingent on the court in the requesting state finding that the requested person was not present at or was not deliberately absent from their trial. A European Arrest Warrant, the warrant, sought the surrender of the appellant to Romania to serve a sentence imposed in Romania for a burglary committed in Romania. The appellant was arrested pursuant to the warrant. The question as to whether to extradite the appellant was determined by a district judge by reference to the questions set out in Section 20 of the Extradition Act. The district judge found that the appellant had not been present at the trial at which he was convicted, and he had not deliberately absented himself from that trial. Accordingly, the district judge was required by Section 20, subsection 5, to determine whether the appellant would be entitled to a retrial or on appeal to a review amounting to a retrial on return to Romania. The information as to whether the appellant would be entitled to a retrial is ordinarily contained in the warrant, but the requesting Romanian Judicial Authority had not completed the relevant part of the warrant. Accordingly, the Romanian Judicial Authority was asked for further information. The question posed was simply, please, can you confirm if he has a right to a retrial? That question was posed on several occasions, including by the district judge. The Romanian Judicial Authority did not reply to the question, but rather indicated that the appellant could request a retrial, but said nothing about the likelihood of the request being granted. The Romanian Judicial Authority also referred to the provisions of Article 466 of the Romanian Code, headed Reopening Criminal Proceedings in case of an in absentia trial of the convicted person. The district judge concluded that the appellant had a right to a retrial in Romania, even though he was required to make an application for a retrial, and the success of that application was contingent on it being demonstrated that he had not deliberately absented himself from trial. The district judge therefore ordered the appellant's extradition. The appellant appealed to the High Court, which recognized that there was considerable force in the appellant's submissions that on a natural reading of the words used in Section 20, subsection 5, an entitlement to a retrial cannot be dependent on a substantive contingency, such as the courts in Romania finding that the appellant was not deliberately absent from his trial. However, the judge considered that he was bound to follow the earlier decision of the Divisional Court in the case of BP against Romania, that Section 20, subsection 5 will be satisfied even if the right to a retrial is conditional on a finding by a court in the requesting state that the requested person was not deliberately absent from that trial. Accordingly, the judge dismissed the appellant's appeal, but he certified points of law of general public importance, and this court granted permission to appeal. The Supreme Court unanimously allows the appellant's appeal for the reasons set out in a joint judgment given by myself and Lord Burnett, with which the other justices agree, which reasons I will now briefly summarize. First, the natural and ordinary meaning of the words in Section 20, subsection 5 are plain. The judge must decide whether the requested person would be entitled to a retrial on return to the requesting state. The answer to the question cannot be perhaps, or in certain circumstances, the appellant is entitled to a retrial. The entitlement to a retrial cannot be dependent on any substantive contingency, because the district judge and the judge in the High Court were bound by the decision of the Divisional Court in BP against Romania. That decision incorrectly construed Section 20, subsection 5. Second, Section 20, subsection 5 does not require the judge to decide a different question, namely whether the requested person is entitled to apply for a retrial. Third, the entitlement to a retrial can be dependent on purely procedural matters, such as making an application in the manner and in the time prescribed in the requesting state. However, if the entitlement to a retrial is contingent on a finding that the requested person was not deliberately absent from his trial, the proceedings leading to that finding would not naturally be referred to as a procedural step. Rather, those proceedings in the requesting state should be regarded as involving a decision on a substantive issue. Fourth, this interpretation of Section 20, subsection 5 is also consistent with the scope of the right to be present at trial under Article 6 of the European Convention on Human Rights, as interpreted by the European Court of Human Rights. Applying the correct interpretation of Section 20, subsection 5 to the present case, there was no information in the warrant or in the further information provided by the Romanian Judicial Authority to establish that the appellant was entitled to a retrial on his return to Romania. Rather, all that was established was that he was entitled to apply for a retrial, and whether he could obtain a retrial was contingent on it being demonstrated that he had not deliberately absented himself from trial. Accordingly, it had not been established that he was entitled to a retrial, so the district judge should not have ordered his extradition. The appeal is allowed, the district judge's extradition order is quashed, and an order is made discharging the appellant.
The court is now adjourned.